Thank you very much for the introduction, Mark. And good afternoon, ladies and gentlemen. The mysterious world of ADR. I shall be facilitating the conversation this afternoon on an issue which I venture to say has not been fully considered by both the insolvency and ADR communities. And that is how ADR can coalesce with the insolvency and restructuring process and assist in resolving issues that frequently come up, particularly in a cross-border setting. I'm fortunate to share this panel with members who really need no introduction. It is obligatory, however, that I say a few words about each one of them, and I shall. First, I start with Jim Peck. Jim is very well known to all of us, and he really needs no introduction. His resume is long and illustrious. After a distinguished career on the bench of the Southern District of New York, Jim has built a substantial practice in insolvency mediation at Morrison and Foerster, where he's global co-chair for business restructuring and insolvency. Next, Steve Kargman, who's also very well known to all of us. Steve has a special interest in sovereign debt restructuring, having advised multinational agencies and national governments in emerging markets and developing countries. Also, Steve is a long-serving co-chair with Christoph Paulus of the III Sovereign Debt Restructuring Committee. Tom Heather, who's on my left, is widely recognized as one of the leading practitioners in Mexico and Latin America in the space. Tom founded the Mexican Mediation Institute and is a member of the Mexican Arbitration Academy, amongst others. Tom has also written extensively, more than 100 articles. And finally, we have Dr. Robert Kovacs. Robert has an extensive practice in international and commercial arbitration and investment treaty arbitration. He has published many articles in this area and also teaches at the Swiss International Law School. In fact, his paper, A Transnational Approach to Arbitrability of Insolvency Proceedings, is one of the issues we will consider in this session, won the III Gold Medal in 2012. I start by setting out what Jim has described as the framing reference for this session. The reference asks the following questions. If not ADR, are we left with only a court-based process for the resolution of issues in an insolvency or restructuring? Is a court-based process the best way of unraveling negotiation blockages, building consensus, reducing acrimony, and achieving savings of cost and time? In short, is litigation or a court-based process the best way of securing a good insolvency solution? It's the submission of this panel that the answer is perhaps no. It is our further submission that we have not fully harnessed the potential of ADR in insolvency and restructuring. These submissions feed into and speak to the title for this session, the ADR Alternative, a New Approach for a New Age in Cross-Border Insolvencies. Obviously, this is a vast topic with a myriad of issues. As regards mediation, there is the difficult issue of consent to mediate. Can mediation be court-directed against the wishes of dissenters, or does it have to be a consensual process? Would such a power have to be legislated, or is it within the inherent powers of the court to direct mediation? The case law, unfortunately, and the commentary on this particular issue from several jurisdictions do not speak with one voice. On arbitration, the issues are even deeper and complex. Consent to arbitrate is an obvious issue. Arbitration cannot be directed by the court, as the architecture of the New York Convention and the model law on arbitration are built on the foundation of an arbitration agreement. There are other difficult issues such as choice of seat of the arbitration and the lex arbitrae and the law of the arbitration agreement and the absence of appellate review on the merits of an arbitration award. But perhaps the biggest elephant in the room in the context of insolvency is arbitrability. Exactly what issues in an insolvency can be the subject of an arbitration, as arbitrability falls within the public policy exception under the New York Convention and the model law on arbitration. Here, it's important to bear in mind the distinction between core and non-core issues in an insolvency when you discuss the question of what is arbitrable. Finally, and this touches on both mediation and arbitration, there is the question of confidentiality. Both mediation and arbitration are confidential processes, and insolvency, as we know, is obviously not. It is not possible in a 1-hour session to deep dive into all these issues. At best, we can scratch the surface, identify the potential of ADR, and peak interest, leaving fuller consideration of the principles and guidelines to a more intensive undertaking, perhaps a III project. Some have argued for a convention and a model law to address the issues which I've identified, but we do know that these take time to be developed and for consensus to be built, and even longer to be ratified and adopted. The time spent waiting may be time lost. The panel will also segue into sovereign debt restructuring and examine whether there are parallels to be drawn and lessons to be learned. So with these opening remarks, I'll turn to the first issue, and this is a general discussion of what we see as the benefits of resorting to ADR in the context of insolvency. And I'm going to turn to Jim first and ask Jim to express his thoughts on what he sees the benefits, seems to be the benefits of ADR.
The greatest benefit is that a judge doesn't have to decide the dispute at hand. That's a benefit to the judge and it's a benefit to the parties. And I first recognized that benefit when I was sitting on the bench now a number of years ago. And I recognized that there were some disputes that, frankly, both the court and the parties would be better off solving themselves. And there are different ways that that can occur. At the most brutal level, a judge will frown or make some comment from the bench suggesting that the parties should consider settlement. That doesn't involve mediation, obviously. Perhaps the next level would be the kind suggestion, have the parties considered going to mediation? That can lead to mediation or not. Another level would be for the court to actually order mediation, although I have my doubts as to the effectiveness of court-ordered mediation when parties themselves aren't ready for it, or the case itself might not have ripened to the point of actually being ready for mediation. My first experience when I was on the bench in the benefits of ADR occurred within the Lehman bankruptcy case, and a protocol was established. It was somewhat controversial, that referred all of the litigation associated with derivative contracts that were in the money to Lehman to mediation. And there was a panel of mediators that was appointed by the court pursuant to a very detailed order that had been developed by the lawyers who represented Lehman. That was an extremely successful process. From the perspective of the parties, settlements were arrived at that yielded billions of dollars for the benefit of the estate and its creditors. But more particularly from the perspective of the bankruptcy court, it afforded a tremendous benefit by offloading a tremendous number of cases that otherwise would have had to be tried if not settled. So there is a case administration benefit associated with mediation within at least the US system. I'm also going to share something that arose on Sunday within the meeting of the Judicial Committee that took place. Ordinarily those conversations are sacrosanct and silent, but I think I can comfortably share that we talked about mediation within the context of those conversations. And what I think many recognized was that mediation and chambers conferences in tandem represented very important case management techniques. Parties need to communicate with each other and with the court, and sometimes that communication is stilted by the pleadings that are filed, the positioning of parties, and frankly, the stubbornness of parties. Mediation is, at least as I've experienced it, an extremely effective way to get people out of their own way, to get people, even though they may not appear willing to do it at first, into a consensual process as opposed to an adversarial one. And they either come to that on their own or they're cajoled into it with the intervention of a judge that wants to do it. A couple of comments, at least about the U.S. experience, and then I'll bring this short monologue to a close. At least in the Southern District of New York and in the District of Delaware, over the last, call it 10 years, there has been an increasing use of mediation to deal with not just two-party disputes in an adversary proceeding, but plan of negotiation problems of negotiating the fundamental plan, the breakdown in discussions between secured creditors and unsecured creditors, the breakdown in discussions within various ranks of bondholders. Mediation has proven to be an extremely effective way to get parties out of their own way and toward consensus that leads to confirmed plans. That experience, I think, is something that we can talk some more about, but it's a sign that at least this form of ADR is efficient, saves money, and actually works in practice because it produces consensual resolution.
Thank you, Jim. I think the point that undergirds your remarks is the capacity of the court to compel parties into mediation, which I think is an issue we'll have to touch on, because I'm not sure whether that position is reflected in the other jurisdictions. But before we get there, Tom, would you like to share the experiences in Mexico and Latin America?
Thank you very much. I would start by saying that in Latin America generally, and more specifically in Mexico, there's a persistent insistence of form over substance as far as insolvency procedures are concerned. There's a concern by the Mexican federal judiciary that deviations from even the more basic formalities may lead to challenges of violations of constitutionally protected rights of due process and, God forbid, human rights. So even though there's this concern, and we're very much oriented, unfortunately, over form over substance, in Mexico, and to a lesser extent in other jurisdictions in Latin America, we have the figure of a type of statutory mediator. It's called the conciliador, whose job it is to get the parties together, or I would say the job should be to get the parties together, to reach what may be an acceptable workout. And consequently, I find that mediation is quite inseparable from insolvency generally. Now, as to arbitration, it is generally assumed that arbitration is inappropriate in connection with any insolvency process, given that the proposition of a concurso, a concordato, a Chapter 11 is a collective process binding on all creditors, and there's also the issue of consent. Nevertheless, as I will mention further on when we talk about some of the practicalities involved, we have utilized successfully an arbitration in connection with a Mexican concurso where there were issues relating to the valuation of complex derivatives.
And has it been your experience that the use of mediation in your jurisdiction, the jurisdictions you touched on, Tom, have been positive? Has it been helpful in facilitating positive outcomes?
It depends. Generally, it has, although there have been, first of all, we have very few formal insolvency proceedings involving any type of corporate entity that has substantive assets or debt. I'm talking about $300 million range. Maybe there's been less than 30 cases in 19 years under what we call the new law. But I think mediation is something that is embedded in the role of the conciliador. Certainly the institute in charge of overseeing the process called the IFECOM has taken a different look. They want to make the conciliador a paper pusher, basically. I believe it has been highly successful, generally, although as of late, it's been very contentious in the context of very, very heavy litigation involving different jurisdictions, as the case of Oro Negro, which you have heard before.
Yes, we will come to Oro Negro in the course of this session.
We will.
Yes.
Yes,
Steve, I'm going to just ask you very quickly to comment on whether there is space in the sovereign debt restructuring space for the use of mediation and arbitration.
Christoph Pallas and I think there is. The fundamental point about sovereign debt is that there is no law for sovereign debt restructuring, and there is no court for sovereign debt restructuring. It was mentioned earlier that one of the objectives of ADR is to avoid a court-based process. In the Argentina case, there was a court-based process based on New York law-governed debt instruments, and that took place in the Southern District of New York before the late Judge Grisey. But that was not considered a very satisfactory experience by many of the parties, except certain holdout creditors. Christoph and I have proposed, we proposed this back in 2008, establishing a sovereign debt tribunal that would handle arbitration and mediation of sovereign debt disputes. And we envisaged a permanent institution for doing that, and the permanent institution would involve a panel of experts, a standing panel of experts from various fields relevant to sovereign debt. So that might involve people from the finance area, from development economics, legal experts, and we thought that that was very important because it brought an element of expertise to the process, which expertise is often lacking in the sovereign debt restructurings we see around the world. We also thought it was important to have such a body, a sovereign debt tribunal, because it would provide a neutral forum for the parties. These disputes can become highly heated, as the Greek dispute demonstrated, among others. And so we thought that establishing an independent body providing a neutral forum would be very beneficial. And finally, we thought it would be useful to have these disputes addressed in one forum. As it is now, with no governing law for sovereign debt disputes and no one court, these disputes can end up in the national courts of various jurisdictions. So we thought it would be helpful to have a focal point for addressing the sovereign debt disputes, and that was in the form of our proposed sovereign debt tribunal. We presented this proposal to the UN back in 2008, and like many of the proposals for reform of the sovereign debt restructuring machinery, there hasn't been much concrete movement to reform that machinery, but we remain optimistic.
Thanks. Now, I'm going to move on to the issues that we think could be productively dealt with in ADR. And I'm going to ask the panelists to comment on three possible areas that could be the subject of ADR. And in this context, we're not differentiating between arbitration and mediation, because that's the question of arbitrability comes into play, but just as general discussion. The first issue is the use of ADR to resolve or to develop a restructuring plan. That's one issue I'd like to comment on. The second issue is the resolution of disputes between affiliates in a group restructuring. The third possibility is the resolution of COMI. Could the issue of COMI be the subject of ADR? And again, as I said, we are not differentiating between mediation and arbitration. And let me start with Robert first. And you can pick up any one of the issues, Robert, and express a view.
Thank you, Ramesh. Thank you for inviting me on this very distinguished panel. So, I mean, I'll come from this from an arbitration perspective, and particularly an international arbitration perspective. And so, the first thing you have to think about whether or not a matter can be resolved by arbitration is whether it's arbitrable. So whether the matter is capable of determination by arbitration in the words of the New York Convention. And this is an issue that has been resolved differently in different states and different countries, but typically you have to look at whether or not the matter is a core matter, a core to insolvency proceedings, or a non-core matter. And generally speaking, although you have to look at the specific law that applies, if it's a non-core matter, then it can be resolved by arbitration. So I think looking at it from that lens, it's a good way of addressing whether or not the three issues that Ramesh mentioned can be resolved by arbitration specifically. And so, I mean, for what it's worth, my view on whether or not a restructuring plan can be resolved by arbitration, I think it's quite possible that it could be, and then that plan can be, the parties to the arbitration can put forward their views, and an arbitrator could make a decision. But then that has to ultimately be accepted by an insolvency court somewhere. So it can't probably go the full way, but it can definitely be a binding on the parties to some extent proposal.
I hate to break in, but have you ever seen that happen? It sounds preposterous to me that parties would actually submit their commercial dispute to an arbitrator that they could be negotiating among themselves, and if they fail, well, then they can go to court.
No, I haven't seen it happen. I mean, this is very theoretical.
Okay.
And frankly, I don't know if it would necessarily. But disputes between affiliates, I think that's something that, as long as it doesn't affect other creditors, could definitely be resolved by arbitration. So, the affiliates could enter into an arbitration agreement, whether that's pre-insolvency, in whether it's a debt document, or post-insolvency, and then that could be a binding determination on the parties to that agreement. As long as it doesn't affect other creditors, then that can go into the estate as well. The COMI, I don't think can be resolved by arbitration. I think that's a core matter for bankruptcy proceedings, generally speaking. So I'll leave it there.
Thank you. I think I would share your view on the use of arbitration to resolve issues such as COMI, because I think those are core matters for arbitration, and really that's for a court to decide whether COMI exists in jurisdiction X or Y. So I share that view. But Jim, I mean, in the context of use of mediation on the specific issue of COMI, is there scope for deployment of mediation to resolve a disagreement between estates as to where COMI resides, rather than having the issue ventilated in 2 or 3 courts?
Look, I've certainly never seen it. It seems to me that that's ultimately a question to be decided by courts. I don't know that you can stipulate to COMI being in a particular jurisdiction, especially if the factors that would ordinarily go into the assessment don't, in fact, lead you to the conclusion that it belongs in that jurisdiction. But we had a conversation yesterday during the course of the panel discussion on forum selection, and I recall that Justice Snowden made some comments about some of his practices in dealing with UK schemes of arrangement. I have had some experience in, and I know others in the room probably have as well, in providing expert witness statements in reference to the recognition of sanctioned UK schemes in other jurisdictions, particularly the United States, and I know that opinions of that sort are given with respect to other jurisdictions. But it's also true that in the assessment of the risk, I guess you can call it, of whether it would be recognized, experts do opine on whether or not it is likely that the scheme upon sanctioning would be recognized, but also in the process tend to examine various factors leading to a Comey determination, especially in reference to the migration of enterprises into the UK from other jurisdictions, including in continental Europe. And it occurs to me that if there were an objection, and this is totally hypothetical, if there were an objection to that scheme, an objecting party might engage its own expert to come up with reasons why it's inappropriate for a UK court to recognize Comey and the change of governing law and the submission to jurisdiction as being appropriate connections to the UK. And in that setting, it seems to me that in an effort to resolve the dispute, the parties might go to mediation, and that the experts themselves who were involved in coming up with those various conflicting conclusions might help to bring about some sort of compromise that would ultimately be resolved in dollars as opposed to a Comey selection. I'm assuming that this is part of a commercial dispute.
So I'll take that as a yes. There's scope for using mediation in the context. I just want to scroll back a little bit to the point that Robert touched on, and this is in the context of arbitration, and he made the point about the distinction between core and non-core disputes and what is arbitrable. And I think, Robert, your point was that Comey is not an arbitrable issue, if I heard you correctly.
Yeah, that's correct.
Now, I mean, the general distinction between the core and non-core world is pre-insolvency rights are, generally speaking, arbitrable. And rights which arise by reason of the insolvency, for example, clawbacks and preference claims, are not arbitrable. And I just wanted to, in this context, raise a recent decision by the English High Court, which sort of signals maybe a different approach. This is the case of Nori Holdings Limited and Public Joint Stock Company. And briefly, the facts in that case, just to give you a context, was a Russian bank had lent a significant amount of money, I think it was US $500 million, to various companies incorporated in Cyprus and a few other jurisdictions in Europe. And the loan was secured against equity which was held by the borrower in subsidiaries which had substantial real estate, valuable real estate in Moscow. Sometime in August 2017, the bank and the borrowers refinanced. And the effect of the refinancing was to take away the collateral for the benefit, take away or rather to make the bank an unsecured creditor. So from a secured position, the bank became an unsecured position, so unsecured creditor. And about 3 months after that transaction, the bank went into administration in Russia. And the administrator then commenced proceedings in Russia to declare the transaction that took place 3 months earlier as an unfair transaction. It's a preference transaction because the bank had been denuded of its collateral. 3 months after the bank had commenced proceedings in Russia, pursuant to the collateral agreement, the borrower commenced arbitration proceedings in London. The arbitration clause in the collateral agreement provided for London as the seat of the arbitration under LCIA rules. And the borrowers sought a declaration in the arbitration that the transaction was valid. And the administrator then brought proceedings in London to, basically it was an anti-suit injunction to say you can't have this issue in arbitration because we've got the same issue in Russia being argued in the insolvency. And that was the issue that was before the English court. And the English court then came to the view that the substantive inquiry in the arbitration was one of fraud, and fraud was arbitrable. And therefore, one should not look at the form, one should look at the substance of the inquiry in the arbitration tribunal, and said, therefore, the anti-suit injunction should not be granted. Now, in my view, that this seems to be a signal of a broader view of what is arbitrable. And Robert, since you sit in London, I'd like to invite your comment on this case.
I'm a bit reluctant in some respects to comment on whether or not I agree with the outcome of the case, because I think that it's potentially taking a broader look at what is arbitrable and moving into some areas that traditionally were matters that weren't arbitrable, weren't subject to arbitration. So it's potentially a move in that direction. Another way of looking at it is that sort of the UK court's taking a very sort of pro-arbitration view and letting arbitrators at least decided in the first instance, and then potentially, if it can be challenged because it wasn't a matter that could be arbitrated, then there might be some sort of setting aside proceedings. So it may be that sort of deference, but it's a curious decision, I would say, from at least traditional perspective of what is considered arbitrable and what is not.
So, Robert, just to pick up on that point, what would you regard as the utility of arbitration in the context of insolvency? What issues could be sent to arbitration? I mean,
I think typically a sort of pre-insolvency claims, proof of debts, that sort of thing, are very good to be determined by arbitration. And some of the advantages of arbitration is you can choose a neutral venue. It doesn't have to be resolved by necessarily the courts of the insolvent party that you may not have that much confidence in. You can choose experts to resolve those disputes. It can be done very efficiently in some cases. I mean, not always with arbitration, but if it's quite a simple dispute, it can be done very efficiently. You also have the ability to have emergency arbitrators appointed. So they could be appointed in a matter of days and make at least interim decisions. So it's those sort of proof of debt claims that are the best, I think, to be resolved by arbitration. But once you sort of start getting into determinations of clawbacks and matters that an insolvency practitioner really should be determining, or the courts, that gets more problematic.
But one of the things that I've observed is that arbitration can go on in parallel with an insolvency proceeding in the U.S., and I know of a variety of examples where an arbitration has been pending, say in London, in reference to a contract dispute, and it constitutes an asset for the Chapter 11 estate. That very often is on a time scale unrelated to the actual time scale of the bankruptcy itself, and so parties in interest in the bankruptcy case are aware of the arbitration. They don't have all the information that they might want to have in order to value the asset, which would be a receivable, sometimes a very significant one. And so I've seen Chapter 11 plans take into account the unknown recovery to be had on the arbitration. It could be a zero, or it could be very significant dollars. But one of the challenges, frankly, is that the arbitration is impenetrable in terms of discovery and getting access to it because it's confidential. And creditors' committees and other parties in interest essentially take a wild guess and take a chance on the plan which takes into account that contingency.
Steve, arbitrability is not a problem in the context of public sector debt restructuring, isn't it? It's not a relevant consideration, isn't it?
Well, there are various issues that could be subject to arbitration in the sovereign debt area. One of the primary areas would be the issue of sustainable debt, which is fundamental to any restructuring of sovereign debt, and there are often very divergent views of what constitutes sustainable debt for a sovereign. The sovereign, of course, wants the figure to be as low as possible, and the creditors want it to be as high as possible. And in the sovereign context, IMF often plays a central role in doing the so-called debt sustainability analysis. But other parties may have their own views as to what sustainable debt is. And for example, developing countries, they're very concerned about if there's a sustainable debt figure that doesn't take into account their social spending needs, their needs to spend on education, health, welfare, that sustainable debt analysis could be very misleading and, in fact, harmful to their society. So sustainable debt would be one obvious issue. Another issue that could be subject to mediation and arbitration would be the validity of underlying assumptions of the restructuring plan. Venezuela will be, when it happens, will be the next big sovereign debt restructuring, and oil lies at the center of the Venezuela story. So there will be discussion, most likely, of what the price of oil will be over the term of the restructuring plan, and that's another issue that could be very hotly disputed. In fact, in the Iraq restructuring from the early 2000s, the international lenders there, the official sector in particular, they had one very conservative view of what the price of oil would be in the coming years, and many of the creditors, particularly in retrospect, thought that the official sector understated the upside potential of oil prices. So that would be another issue, would be validity of the underlying financial assumptions. An issue that is unique to the sovereign debt world is the issue of odious debt. I won't call it a doctrine because there's debate as to whether it is a recognized doctrine, but the question of whether certain debt incurred by a regime is odious debt and is therefore effectively unenforceable, that's an issue that could have come up in the Iraq setting in relation to Saddam Hussein's use of borrowings, but it also may come up, for example, in the Venezuelan context. Venezuela has borrowed a lot from Russia, and those borrowings were used in part for military purchases. So that issue may come up in the Venezuelan restructuring if and when it comes to pass, and so odious debt might be an issue that would be appropriate for arbitration. So the issues that would be dealt with in arbitration of sovereign debt disputes would be fairly distinct from the issues that we've been talking about in relation to commercial insolvency issues.
Right. I'm going to move on to, and I'm coming to you, Tom, on how we can go about implementing mediation and arbitration. In fact, we've talked about the issues. So how do we operationalize this? How does a court push a matter into mediation or push a matter into arbitration? And I first would like to ask you, in the context of mediation, how would it happen? I mean, how would you procure the consent to arbitrate or the consent to mediate from parties?
Okay, thank you. I would say just very quickly, again, to emphasize the fact that in a way the Mexican law was intended to create a type of statutory mediator. It's a job to carry out the efforts to reach an agreement, a plan. Now, as I also mentioned, there's been a case where the use of arbitration was useful, and certainly people were very skeptical where it could be used. And it worked because of several reasons. This was related to the technical valuation of very complex derivatives, where the banks had spent maybe 7 months, 6 months in just arguing who had made the right closure of the derivative, close the derivative in a time of incredibly high volatility of the Mexican peso. And so it worked because, first of all, the banks realized they needed to reach a consensus when we were running out of time, because there's a specific time frame for the Mexican insolvency process to work in the conciliation stage, the workout stage, because then it becomes a liquidation. So in a way that was helpful. It's usually not helpful, but it was helpful in that case. Second, it was kept simple. It was a one-letter agreement in which the banks chose their expert panel. They made the determination. These 3 top professors, mathematicians, can help us out. And third, I must say it worked because we kept it outside of the court. So we would ask the judge, the answer would probably have been, this is a law of public order and we have to emphasize, and we kept it outside. It worked, and even though people were very skeptical within this context of procedural judicial scrutiny that we're so hung up on in Mexico, it really helped the process move along. So I would say what's arbitrable, what can work, very difficult to define, but probably if there's a case, a matter that can come out, we'll probably know it when I see it, as somebody said.
Sure. Jim, so I'm going to come back to turn to you, and this is an issue which, in preparing for this panel, has troubled me. So you've said as a judge, and now you act as an insolvency mediator. The question is the question I posed to Tom as well. How do you compel parties into mediation? Does the court have the power to override unwillingness to mediate? I think we'll discuss arbitration separately, but in the context of mediation, how do you force someone into mediation when he doesn't want to mediate?
Only through extreme measures. The court really has no power to compel parties who are unwilling to mediate. They can be ordered to mediation, but that doesn't mean that they're going to do anything other than check the box that they went through the mediation. There's an element of good faith that is built into this process. There's an old joke about how many bankruptcy lawyers does it take to change a light bulb? And the answer is only one, but the bulb has to want to change. And this notion of consensus building can't really be compelled. It's circumstantial. And I think that courts have the capacity, and I suggested this in my earlier remarks, to make it very clear to the parties that the court wants them to engage with one another, sees it as an advantage not only to the court but to them, and recognizes obdurate and unreasonable behavior as something that's just unacceptable, particularly in plan negotiations. Courts are sensitive to that. And the parties themselves who are going to be appearing later in a proceeding are sensitive as well, and they're going to want to please the judge. So they'll say yes. They're unlikely to resist kicking and screaming all the way. But what happens in that mediation is more difficult to predict. I mean, it seems to me that for ADR, especially the consensual type that we're talking about here, to really work, parties have to recognize the benefit of a transaction. And that's a form of risk assessment that requires a level of realistic and sophisticated appraisal of outcomes. And sometimes the mediator, even in a setting in which the parties have come to the process with some resistance, mediators can open minds a little bit by pointing out some risk factors that were not effectively weighted by a recalcitrant party. And look, many of the parties that we're dealing with in complex Chapter 11 mediation are hedge funds. They're very, very stubborn. They have strongly held views as to their entitlements. They have read documents that govern their rights with great care and deliberation and have made investment decisions based upon a particular theory of how the documents should be interpreted, and they will press hard. It becomes very difficult to deal with those parties in a mediation. It takes a very skilled mediator or adversary to that party to create a proposition that implies a greater risk. Essentially, what we're dealing with in any mediation is legal uncertainty and what the court's going to do. So every mediation is occurring within a context of, well, what happens if the mediation fails? And if what happens when the mediation fails is that one party is likely to lose, it would make good sense to settle at a level that is above zero.
Thank you. Jim, I think there's one big difference between the US and perhaps the rest of the world, maybe except Australia. I think the US cases have said quite consistently, and there are several cases which have said this, the US courts have the inherent, inherent powers of case management to compel mediation. So if you take your example of your hedge fund holdout, even if that hedge fund creditor doesn't want to get to the table, the court can say you go and mediate. Whether the mediation sees a successful outcome is a different issue, but you can direct the party into mediation. Unfortunately, the position in the UK, for example, is that the court doesn't have that power. There's actually a reported judgment on this point. And I don't think, I stand corrected, Jonathan might correct me, but based on the Law Commission report in Hong Kong, I think the Hong Kong position is very similar to the UK. Australia has legislated on this point, and Australia now has, the courts have statutory powers to compel parties into mediation, even if they don't want to mediate. So clearly there's a problem here if the court perceives itself as not having the powers to force parties to the table, even if, because the court feels there's an opportunity to strike a deal, then you have a natural impediment to using mediation to its full effect. So I'm going to just move on very quickly to the question of arbitration, and I'm going to use the example of Nortel. I think Nortel is a good example of what can be arbitrated, because there was a big dispute as to how proceeds should be divided amongst various estates, and really there was a issue of rights as opposed to insolvency related matters. But Tom, I just want to ask you, so if one were to structure an arbitration agreement in the context of Nortel, there are various issues one has to consider. One is obviously the seat of the arbitration has to be dealt with. There's also the question of the consent to arbitrate. How would you get a consent to arbitrate that would bind all the estates? There's obviously the question of the lex arbitrae and the law of the arbitration agreement, and these are all matters that have to be considered. So if you were structuring an arbitration agreement in the context of Nortel, I mean, how would you navigate that process?
Well, I would certainly consult with Jim, but having said that, I think that the concept is that arbitration can only impair those who have entered into the agreement. And so it is, I would be very skeptical that a Mexican court would have the authority even to propose that or to implement that. So I think it would be very, very exceptional, and I don't think it would work as a matter of our jurisdiction.
Robert, if you were advising on Nortel, how would you put the deal together?
Yeah.
The arbitration agreement?
I mean-
Because without that, you don't get an enforceable award under the New York Convention.
Exactly. I mean, you have to, I think, consider this from the very early stages. So and who are the parties that may be interested or affected. And so, I mean, one of the things I've been thinking about is whether or not you sort of have a model clause, and perhaps something that the III can consider, where you provide for the option or the mandating of arbitration in the event of insolvency, for example. You could do something along those lines that, if an insolvency event occurs, then the parties agree to arbitrate in the right circumstances. I think it has to be carefully considered, but that could be one option. And then that's included in the suite of all debt documents, for example.
Well, the reason why I asked this question is because one of the issues you'll have to decide when you draft the arbitration agreement is the choice of seat.
Correct.
Right? And the seat is such a critical choice because the seat will determine the applicable law of the arbitration as well as the supervisory court of on the award. Right? Now we have got 3 estates in 3 different jurisdictions fighting over the proceeds. The choice of seat presumably has to be a neutral venue. Otherwise you're back to square one. You'll have the issue being litigated in one of the 3 courts which are where the 3 estates are located. So the choice of seat will probably be a very, very important consideration.
Correct. I mean, I think it should almost always be a neutral venue if possible.
Yeah. Now, I just wanted to move on to, we've got about 7 minutes. I want to leave some time for question. Jim, I just want to ask you, and Tom as well, this issue of, there are 2 sub-issues really. The issue of confidentiality. And so if you moved issues which were in the insolvency domain, which is really a public domain, public arena, and you move that issue into a confidential process such as mediation or arbitration, how do you marry the 2 competing considerations of openness as opposed to confidentiality, and how do you ensure you protect the confidentiality of the mediation and arbitration process?
You want to go first, or shall I?
Just very quickly, I would underline something that you already said, Jim, which is there has to be an element of good faith. You have to keep it, very, very focused. The proceeding you're going to move, and it has to be by consent of those that will be affected, and it has to be something that will work and will be unanimous, basically.
Look, there's obvious tension here between the right of parties who are not mediation parties, but parties in interest in the bankruptcy case to know what's going on. Bankruptcy is a notoriously transparent process compared with a fishbowl. The order appointing a mediator and compelling mediation, or the consensual order that the parties work out, inevitably includes strict confidentiality provisions, and the conversations that take place between the mediator and mediation parties are absolutely confidential, and maintaining that confidentiality is of critical importance to the integrity of the process. I mean, I recall just anecdotally that some years ago I was still a bankruptcy judge, and I was appointed by Judge Glenn as mediator in a very large case called Residential Capital, and sometime thereafter, certain parties wanted to gain access to information that was shared during the mediation. And if I recall correctly, Judge Glenn decided that that was off limits. Confidentiality is critical to open negotiation, and most importantly, sharing information with the mediator that is private, where people really live in terms of their willingness to settle, the kind of thing that they would never tell their adversary. And it has to be shared in a setting in which there is complete confidence that it's going nowhere other than between the ears of the mediator. It's critically important, but it's also true that discovery is an essential element of U.S. bankruptcy practice. And I think that those people who are involved in a mediation, especially when there are lots and lots of parties, occasionally violate that. I'm going to share one quick example. Judge Barbara Hauser is mediator in a very large and complex restructuring of Puerto Rican bond debt. And there are so many parties involved, especially during the early stages. Very elaborate agreement is signed. It includes confidentiality provisions, and at least in the United States, there are reporting services like DebtWire and Reorg Research that provide regularly information about what's going on in bankruptcy cases. Notwithstanding the confidentiality restrictions of the agreement pursuant to which parties engaged in the Puerto Rico mediation, the day after one of those sessions, a document that was shared in the context of the mediation ended up on the wire service. Judge Hauser was upset for good reason and admonished everybody, but it happened another time as well. So while there is this strict adherence to the principle of confidentiality, the more parties that are involved, and you have to imagine the number of parties that are involved are more than the people sitting in this room, it's tough to keep a secret.
Now, Steve, very quickly, would you like to talk a little bit about the use of mediation or arbitration in the context of any specific case in the sovereign debt space?
Yes. Arbitration and mediation have not been used to any great extent in the sovereign debt area, but one example at a very minimalist level was the Iraq restructuring of the early 2000s. That was in relation to the Saddam-era debt. And one class of creditors were the commercial creditors. There were many contracts from the Saddam era in relation to construction projects and so forth. So there was about 20 billion of commercial debt, which is not typically a major part of these sovereign restructurings, but there were hundreds, if not thousands, of commercial creditors. But the problem was there were not very good records of the contracts that were entered into. So there was some controversy as to how they would reconcile the debt claims. And as part of the restructuring, they appointed E&Y as the debt reconciliation agent, and they had the responsibility of reviewing the claims submitted by the commercial creditors, and if they were able to verify the claims, that was fine. But in the case that debts were unable to be substantiated, the creditors had a right, the commercial creditors had a right to submit their claims to arbitration. And that related to about 5% of the overall claims. And then an arbitrator would decide whether the documentation was sufficient and verifiable, and they would make a ruling as to whether the debt should be considered properly outstanding. So that was how it was used in the Iraq restructuring. But in terms of some of the issues I've discussed earlier, that's sort of a minimalist approach to arbitration in the sovereign debt context.
Mark, I don't know whether you have time for any questions, or we're just about 5 seconds 4, 3, 2, 1. Well, yes. Any burning questions? Anyone? One, right. It's a forest fire.
Okay, microphone.
I don't know.
Whoever has the easiest question.
Just have a quick comment on the arbitrability about a contract right with an insolvent party. The New York Convention authorized a state to reject recognition and enforcement of arbitral award if there is incapacity. Okay, one contract party, they went into bankruptcy proceedings. I think in some U.S. judgment, we found the judge said, from that moment on, the party does not exist anymore. Also, in China, like from that moment, the court will appoint a trustee or administration to look after the assets or reorganization plan. That means the traditional structure, board of directors, shareholder meeting is gone. It's trustees with the court standing back with the credit meeting standing back. That means the insolvency party does not have any will to conduct any contract issue. That means the basis of arbitration is parties' autonomy. From that moment on, the autonomy is gone. They do not have any ability. I mean, incapacity would be an issue for the arbitration to be going on. So I think let everybody think about that. Thank you.
Thank you. Augustine.
In terms of the legal framework of mediation, perhaps it is worth mentioning, Tom, that the mediation law now contemplates that the mediation agreement, when signed by the parties, is enforceable directly, right?
Yes.
It's a very positive outcome in Mexico. Once you sign, that's like a judgment, res judicata, whatever the term is, that you can go and enforce directly. You don't need to go to court for enforcement as it was the case before.
Yes. Well, there's a convention which is coming into force in August this year, which is built on the architecture of the New York Convention. So, a mediation agreement. The result of a mediation becomes like an arbitration award. It can be registered and enforced like a judgment. So that's going to be a big development. Thanks, Mark.
Thank you very much. Ladies and gentlemen, I'm sorry, that's as much as we've got time for. Would you please join me in thanking this fantastic panel? And whilst they are stepping down, could I just briefly introduce Mr. Justice Jonathan Harris and Luke Chan, who are going to tell us all about the Hong Kong conference.
I know many people in the room are very familiar with Hong Kong. It's an extraordinary and it's a dynamic city. And to those of you familiar with it, it probably came as no surprise that it was capable, with only 3 days' notice, of arranging a meeting of 2 million people in its central business district. It probably will come as no surprise, and indeed you probably expect, as a result, that we don't see much challenging in arranging for a meeting of the III in Hong Kong in June 2020. We're quite well advanced with our programme. We're quite well advanced with the technical programmes, and also John here is going to talk in a little while about the social programme and NextGen. What I'm going to do is hand over now to Look Chan Ho, who's going to talk about what the professional programme will involve. I'll then hand the mic to John, and then have a few comments at the end about the logistics of making applications to attend the conference next year.
Thank you, Jonathan. So in terms of the professional program or the substantive program, so what we are intending to do is to discuss issues that are not frequently discussed in international conferences, in particular in relation to the mainland. There are a few reasons for concentrating on, for example, mainland. That is because if you come to Hong Kong and you want to look at how Hong Kong does things, how restructurings are done in Hong Kong, it would not make sense if we focus on Hong Kong alone. Let me give you an example. Hong Kong is the only place in the world where very often a restructuring is done on the sole basis of a listing status. And that, you can only make sense of that by looking at the interaction with the mainland. So that's why we intend to have a session devoted to the mainland issues, how restructuring is done in the mainland. Some of you may have heard that the debt size in the mainland is huge. For example, Xiamen Judge told me recently he frequently oversees cases where the debt size is about 10 billion RMB, 1.5 billion US. That is nothing uncommon, and frequently is 100 billion RMB. So that's why we want to look at those issues in some depth, and those issues are not frequently discussed in international conferences. Now, of course, we are in Asia. China is not the only part of Asia. We will look at other regions as well. We will also, in particular, look at India. India has kept many people very busy, including many people in Hong Kong. And of course, we will have still the usual international updates from the US and European the developments and so on. So on that note, on the social side, I'll pass this on to our social and entertainment master, John Master.
Thank you, very much. As you can see from the video, we've secured for the conference venue, with Shari's assistance, the Grand Hyatt. What makes that a good choice is that we can both reside there and also have our conference there, so we're in one venue for the duration of the II conference. But if the Grand Hyatt is not to your tastes, within covered walking distance, we have the brand new 6-star St. Regis Hotel. We also have the Harbourfront Renaissance Hotel and a number of other 3-star hotels. And I even say there are some hotels that charge by the hour nearby if that suits someone. As to the social program, we'll be reaching out to members very shortly to see where your appetite is. We don't plan to do things unless there's a take-up of them, so we're going to go out to you early and ask you, are you interested in doing this? Some of the social programs that we're thinking of is, of course, a bespoke eating experience, probably Cantonese because we are in Canton, a junk trip to maybe an outer island for a seafood restaurant, shopping, a walking tour with a cultural element. Jason Wardy is a well-known historian in Hong Kong who will take us around and explain some of the cultural features of the various city highlights. For the next gen program, at the top of my list at the moment, and I'll be going out to them, is maybe Macau tour. Fernando's on the beach out there, absolutely fantastic. So we're concentrating on the members, the accompanying partners, as well as next gen. And as I say, we'll be reaching out to you and asking you what you feel like doing when you get to Hong Kong.
Thank you, John. Now, we anticipate, we certainly are aiming to get the programme finalised or close to finalised very quickly, and to be circulating details to members so that people can apply for visas if you need a visa, and make an application to come to the conference and book a hotel. Now, I think it's worth emphasising a couple of things here. There may be certain components of the conference programme which has limited room. For example, I anticipate we might have a side trip to Shenzhen, in particular to see the Shenzhen Bankruptcy Court, the new bankruptcy court in its new building. We will have a limited number of spaces, and people who are interested in attending that will probably be well advised to apply very early on. Also, I anticipate that there may be considerable interest from professionals and others in the mainland in the conference programme. So it may well be that we will be in the, from our point of view, happy position of oversubscribed fairly early. So those of you who are in the habit of leaving, making your decisions to the last moment, may be well advised to change your habit if you have a genuine interest in attending Hong Kong, which I hope most of you do. So I hope that I'll see most of you next year in Hong Kong, and we should have a very interesting and stimulating programme for you. Thank you very much.